Well, welcome everyone to the Public Safety Justice Subcommittee. I'd like to call this meeting to order. And the first thing on the agenda is call to the public. Matt, do we have any cards for call to the public?
Yes, we do. I believe Mr. Barton had something to introduce first.
Chairman Nowakowski, members of the subcommittee, before we do the call for the public, we do have legal counsel here just to make a brief statement on what the call for the public is, how it works, as well as just to address any other items on the agenda. Julie?
All right.
Thank you. During citizen comment, members of the public may address the City Council for up to 2 minutes on issues of interest or concern to them. The Arizona Open Meeting Law permits the subcommittee to listen to the comments, but prohibits council members from discussing or acting on the matters presented. And Chairman, I also wanted to remind the public of the rules regarding speaking on agenda items. Members of the public may speak for up to 2 minutes to comment on agenda items to be discussed. Comments must be related to the agenda item and the action being considered by the subcommittee. General comments that go beyond the scope of the agenda item must be made in the citizen comment session. Speakers must present their comments in a respectful and courteous manner. Profane language and personal attacks on members of the public, council members, or staff are not allowed. A person who violates these rules can lose their opportunity to continue to speak. Thank you.
Thank you. And with that, Matt, first person on the call to the public.
Yes, sir. For call to the public, we have Laurel Langmead. Laurel, are you on the line?
Yes, I am.
Please proceed.
Yes, I want my statement on when you do the minutes to say that to encourage the city of Phoenix to improve their progress in regards to the public safety in and around the Human Services campus for those that are seeking services and those that live and work in the area. You should have all received a email that I sent regarding the firemen that had to go put out a fire in the tent city there. And they came out saying that they don't want to go there unless they have police protection. It's gone from bad to worse there. And the Madison Pioneers Coalition is going to be contacting each one of you to try to find a path in order to make the place better and safer for individuals. For example, there was a gang going around asking for entrance into the private residences and businesses in there, looking for somebody that they allege is girls that are being taken in, raped, and then forced into porno movies. There was one individual that saw a woman that was just sitting in the middle of the street in front of Andre House, batting at her demons, but nobody from Andre House came to help her. There was somebody that was laying in the gutter sleeping, and a street sweeper came around. The guy didn't budge, but at least the street sweeper went around him. There's a lot of crime that is happening inside the Human Services campus surrounding area that we just need help. There was somebody in the electrical supply house that's near there that was accosted and severely and hurt by one of the criminal elements in the area. So we want to help you remove the hardcore criminal element off the streets and into a different area. And so thank you for your time, and we'll be contacting you all, the Madison Pioneers.
And Chairman, that was our last member of the public for citizen comment.
Alrighty, thank you, Matt. And our next agenda item are the minutes from last month's meeting. Before I ask for a approval of the minutes, I like to make it very clear that at our last meeting we talked about the challenge point, and a lot of my colleagues and also the public wanted that to be an agendized item on the agenda. Seeing that if you look at the agenda, you don't happen to have that on the agenda, can staff briefly explain why the challenge point isn't on the agenda, and about future comments about the a challenge coin? Seeing that we have legal counsel here.
Yes, thank you, Chairman. In regards to the challenge coin, the city learned that a challenge coin may have a connection with the slogan used by white supremacists through press reports around February 6th and promptly ordered an outside investigation. City's lawyers in the Puente litigation received a copy of the challenge coin from plaintiffs in May of 2019. However, a connection to white supremacists and the challenge coin was not raised in May of 2019. We are doing a thorough review of all issues related to the challenge coin and will make our findings available to the public when that work is done. Thank you.
Chairman, I think you may be muted.
Sorry about that. With that, is there a motion to approve the minutes?
Move approval.
Second.
We have a motion and a second. All those in favor say aye.
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 All those opposed? Motion carries. So now we're on agenda, the consent item for number 2, item number 2.
Move approval.
All right. We have a motion. Is there a second?
Second.
Chairman, we do have several people signed up to speak on item 2.
Alrighty. So before we vote on this, we have a motion on the table and we'll listen to the cards.
And Chairman Nowakowski, we also have 38 e-comments in addition to the public speakers.
Alrighty.
Our first speaker is Hava Derby. Hava, are you on the line?
Thank you. Yes, I am here. Good morning. Gosh, you guys want more money for the cops. You guys haven't really described what this is for the public, but we do know it involves the police having more money. Been exposed as corrupt, county attorney, police working together to politically prosecute protesters, and yet you guys want more money. Didn't we just give you guys another $5 million or so plus in some unitemized, I think you had a few thousand in some graffiti, but otherwise you got $5 million for we don't know what, and you want more money. Yeah, we say no. And gosh, I really don't know much about this agenda item. But so I think I'm going to have more to say about the Brady list. So I'm excited to jump into that one next in item number 4. But I say no, as do probably the rest of the callers. Yeah, no more money. Thank you. I yield the rest of my time.
Our next speaker is Vanessa De Carlo. Vanessa, are you on the line? I'm sorry, she is not on the line. Our next speaker is Anissa Groves. Anissa, are you on the line?
Yes, can you hear me?
Yes, please proceed.
Thank you. I'll keep this very simple because it is so simple and you just refuse to do the right thing. We are so tired. I am not going to waste any more of my time coming up with well-researched or thoughtful comments when you want to give money to Phoenix PD. They do not need any more money from any source for any reason. Last time it was barking dogs. Now it's let's find new ways to reward our neo-Nazi police force with public funds for all the people they've already managed to kill and cage this year. We already know they're going to use this money to brand protests as riots after they violently assault people demanding justice and book them as gangs. How many times do we have to prove they can't be trusted with any of this money? Vote no.
Our next speaker is Hannah Heyman. Hannah, are you on the line?
The anti-Black white supremacist city of Phoenix must be stopped. Black residents have been telling you for the past year to remove money from the vastly overfunded and violent Phoenix police, but you have done nothing but lick their boots and praise their white supremacist violence. We know you are capable of listening. Nowakowski goes out of his way at every meeting to repeat every anti-Black white supremacist talking point he can. When's your last day, Michael? The city will be a far better place without you in office. I sincerely hope that we never hear from you again. The fact that you all are even considering more funding for the murderers at PPD is unconscionable. After a year of brutality and the scathing reports of corruption and collusion between Phoenix Police and the Maricopa County Attorney's Office, you're sitting here like nothing has happened. The fact that you're continuing these meetings as usual after ABC 15's reporting is an indictment on your souls. You must immediately fire incompetent Ed and choke.
Could you please direct your comments to the item on the agenda, sir?
And when I say every violent...
Please cut the microphone off. My apologies. Our next speaker is Kelly Kwok. Kelly, are you on the line?
Hello. In my daily life, I work with vulnerable kids, and I have to be ethical. There is a power dynamic every day, and I have a duty to be accountable or face unwanted results. One might forget, but it's the truth. Why do you all act like you don't? Public safety and justice is the name of this subcommittee, yet none of you do anything at all to promote public safety or justice. In fact, you support...
could you please direct your comments to the item?
Police and refusing to use your power to hold them accountable. We have to create citizens' petitions to literally force you to vote.
Our next speaker is Grace Logan. Grace is not on the line. Our next speaker is April McHugh. She is also not on the line. Our next speaker is Lola Nasangu. Lola, are you on the line? Lola is also not on the line. Our next speaker is Karen Olson. Karen, are you on the line?
Hello, I'm here.
Please proceed.
I will. One, I just want to give myself the space right now to acknowledge the true pain that you are putting people who choose to put their voices out here. Like, you are all painfully cutting us off and silencing our voices, which is exactly why we are showing up. Police silence our voices and then you pay them. You literally give them more money that doesn't protect us, that puts us in a place of fear. I literally showed up this morning and have listened to you not listen to my fellow citizens, our fellow citizens. You all are part of this city. We all are responsible for this pain that we enforce on Black and brown bodies, and it's not okay. And it's not okay for us to see time and time again.
Karen, item number 2 is about a Homeland Security grant. If you've got comments germane to the Homeland Security grant, please make them.
Is the Homeland Security grant giving money to police?
The Homeland Security grant funds both police and fire for terrorist activities.
Then I am talking about that because it feels like
your comments are off
terrorists.
base relative to the Homeland Security grant. If you would like to comment specifically on the agendized item, please do so.
I am commenting that I don't want more money to go to the police. I hope you can interpret that as being part of the agenda item. And I hope you will stop gaslighting us all. Thank you. I yield the rest of my time.
Our next speaker is Patricia Paglia. Patricia, are you on the line?
Good morning. I am on the line. We are talking about agenda item number 2, which is a grant that will give more money to Phoenix Police. I need you to put April McHugh, Kelly Kwok, Hannah Heyman, Lola Nsangu, Karen Olson, and Vanessa De Carlo, all who you cut off or skipped over, onto comment number 2 and or the public comments at the end of this garbage presentation. We are demanding you do not give any more money to Phoenix PD. Jeff Barton, how dare you come in here and try to silence us and tell folks that we are not talking about the agenda item. We are not stupid. We read your agendas. We know that you're trying to give yet more money to Phoenix PD, and it's not okay. I don't know why that's hard to understand and it's disgusting. Can you just change the name of this subcommittee to white supremacy and killing people? Because then you can go ahead and talk about the trash that you want to talk about. This is completely unacceptable. Someone on this subcommittee needs to help us to allow us to make these comments, which are completely relevant. And I'll say the names again there for you, Chair. April, Kelly, Hannah, Lola, Karen, Vanessa, let them speak. We are here to demand justice in solidarity with Black lives. Okay, sound good? Thank you.
And our next speaker for this item is Brandon Valentin.
Hello, can you hear me?
Yes, I can. Please proceed.
Y'all are absolutely disgusting for silencing every single person that has came to speak on this. That Homeland Security grant can get thrown out the window immediately. And y'all are sitting here literally cutting people off for not talking about the agenda item. You're talking about the agenda item. I don't know if y'all got ears or not, or like what y'all are interpreting, but y'all need to stop that shit. It's fucking ridiculous.
Sir, could you please
Thanks.
restrain yourself from cursing? Thank you.
Yeah, can y'all restrain yourself from fucking killing Black and brown people?
Please cut off the microphone. Sir, that was our last speaker on this agendized item, and I'm going to check with IT to see if we have. Okay, I'm checking with IT to see if we've had people who have joined.
Already, at this time, I'd like to see if any of my colleagues
Sir,
have any questions.
I think we do have one more person who's come back on the line.
Alrighty, we'll go to that person first.
April, are you on the line?
Hi, good morning. I am here. I'm just here to express my desire to not allow the Phoenix PD or public safety or whoever is applying for this grant. I'm here to express my concern with them applying for this grant. I do not want to allow them to apply for this grant and give the Phoenix police any more money. I think it's pretty ironic that the city has delayed their investigation of the Phoenix Police Department, all while we're here today to discuss more money going to our police. We've said over and over again that we do not want our police to get any more money. We need to investigate our police department and their lies in these false charges and their collusion with the Maricopa County's attorney's office. And we need to punish our officers who have been
April, could you
who have
direct
been
your
lying.
comments to the grant application?
I'm explaining why I don't want our police officers to have the opportunity to apply for a grant that will just give them more money. Already after they take over $700 million of our city budget, after they were rewarded with a $500 million after what they falsely claimed as riots this past summer, which we have been proven to have lied about. They have gotten way too much money already. I do not want them to get any more money. They have way too much money and are abusing their power in our city. And you all are refusing to face the facts and investigate them. We need a private investigation. We can't have police officers policing each other. And we have too much collusion going on between our county and our city. Why do you all just sit on your asses here in this meeting and you act like nothing is going on? You have community members who are dying at the hands of police officers, and they're literally getting away with it. I literally feel like I'm living in an alternate.
Chairman, that I believe was our last commenter. Let me just double check that no one has reconnected. We have not had anyone reconnect. It may have been that there were some issues for those other speakers who were mentioned earlier, and I would just remind anyone that they are welcome to sign up for general public comment at the beginning of the meeting if they so choose.
Alrighty, thank you, Matt. Councilmember Garcia.
Thank you, Chairman. Jeff and Matt, I think whether we agree or disagree with the folks that are on the phone, The fact that they're talking about the police department, I think, makes it relevant to the item. I would like to hear from the folks that got cut off. I think it is relevant that if you're speaking about the police department who's getting a grant, folks should get to speak. Also, there's a couple of folks that were called on that have sent our office a message that they're on the phone. So I don't know if some of the folks that were called on could get checked on. Specifically, I think Lola, she's been on.
Is there anybody else, Councilmember Garcia, besides Lola?
Okay,
That's the one that's reached out to us.
Okay.
and it does
Matt?
appear like she is on, Chairman, so. Lola, are you on the
Perfect.
line?
So I'm on the line. Can you hear me?
Yes, please proceed.
Okay. Just because you don't understand what systemic racism is and how it applies in these situations, and just because you don't understand the reasons that people are giving you why police don't deserve any more funding in Phoenix, does not give you a right to cut people off. Who are you accountable to when you have community members waking up early in the morning, showing up to these long meetings where they rarely ever get heard, coming week over week, month over month to every city council opportunity they have to cut us off? It is very clear. We've had in the Phoenix Police Department officers who perjured themselves, a county attorney who actually solicited that perjured testimony, and how you have them, these officers are getting away. They're actually just reassigned into other duties while they're being investigated for holding neo-Nazi challenge coins. We cannot, especially to that particular group inside the police department, continue to fund them. They've gotten a reimbursement for overtime that they never should have caused themselves to have anyway. They were actually creating their own conditions to be able to make sure they could get more money for their lies, for their targeting of people who were protesting them. They are unfit. There is no reason at all why we should be even considering giving them any more money at all. And yes, no, this is relevant. It's relevant. So you have to sit and listen to the community. That is your job. It is your job. I don't understand why every single month we're here and I'm watching everybody slow blinking, pretending that they're listening, probably shopping on Amazon as council members. You have to do something. How are you sitting here ignoring people every single month, literally voting against the voices that come here every single time, telling you what not to do? Here in this subcommittee, that is your job. That is what this is. And now, Kowski, how can you sit here for this entire time as the chair and forget your job? You guys need to vote in favor of what the community is saying. Otherwise.
And it appears that Vanessa De Carlo is also on the line now. Vanessa?
Hello, can you hear me?
Yes, please proceed.
Yes. So the Homeland Security Grant, agenda item number 2, that money that is used to over-police, to target the protesters, to try to falsely set up these charges that are outrageous, that's what that money is being used for. No more money, no more. It's enough. We don't need to fund this neo-Nazi ridiculous murder machine. Listen. This item number 2 is funding this atrocity, this absolute horrible corruption that is occurring. I cannot even imagine how you can sit there and give more money to somebody, to an agency that is this foul. It is unbelievable. All of the collusion between the Maricopa County Attorney's Office, everybody, every prosecutor that is involved, that money is used to fund this. No, do not say yes to this item. This is outrageous.
Matt, is there anybody else on the phone?
Chairman, no, there is not.
Alrighty. Councilmember Garcia, do you have any other comments? Already, any other comments from my colleagues? If not, there's a motion on the table. All those in favor say aye.
Aye.
All those opposed?
No.
The motion carries. We're on to item number 3. This is for information only. Does anybody need is there any cards on this item, Matt?
Chairman, there are not.
Chairman, there are three
Alrighty.
e-comments, but no speakers.
Alrighty. And have my colleagues got those e-comments and we're able to look at them? All right. So this is for information. If anybody needs any information on this, we can hear it now, or we can just go on to item number 4. All right, we'll pass it on to item number 4. Item number 4 is the Brady. So do we have our speakers ready? All right, Mr. Myers, it's all yours.
Thank you, Chairman, members of the subcommittee. Thank you for the opportunity today to be here to explain the Brady list. There's a lot of discussion about it and a lot of things being said about it in the media and the public, and I think a large amount of misunderstanding about what it is. So we appreciate the opportunity to come and explain it today. With me today are Bob Smith, the city prosecutor who oversees the prosecutor's office, who is going to explain the Brady list and what it is. And also with us today is Elizabeth Ortiz from the Arizona Prosecuting Attorneys Advisory Council, who is going to talk about something that they are involved in and trying to make the Brady list more transparent and to make it more usable for especially the smaller jurisdictions, but jurisdictions around the state. So with that, I'll turn it over to Bob to discuss the Brady list.
Sorry. Let me repeat that. Good morning, Chairman. Good morning, fellow council members of the Chairman. And I'm here to give you some information related to the Brady Rule 15 process. Thank you, Chris, for the introduction. And I also would like to welcome Elizabeth Ortiz that will be speaking with a separate presentation after mine. I first want to talk about the term that's used, and you'll see the agenda item is Rule 15 disclosure process, Brady, that it's not actually a list. What this is about is for a court case, we're determining whether or not there's something alleged misconduct with an officer or another state witness that we're required by multiple basis to disclose to the defense, and I'll get into that further detail. But this is not a mechanism for police oversight or discipline. That would be handled internally with their department, and we do not determine whether the allegations in the underlying reports are true. This is information to give to the defendant, so he or she has a fair trial in the City of Phoenix Municipal Court. So the sources of the Brady, it's an obligation by any prosecutor's office, is the 5th and 6th Amendments to the U.S. Constitution. What's important about that is the 5th Amendment, that the right to due process. This is part of the due process of a trial for a defendant. The 6th Amendment would be so the defendant has the right to confront the witnesses against them, because this is related to witnesses. Cases that interpret the Constitution, and that's, so everybody's aware, that's where the term Brady comes from. There was a 1963 U.S. Supreme Court case that held that the prosecution has to disclose information that might mitigate, negate, or go to punishment of a defendant. The cases interpreting the Constitution include Brady and several cases that came after Brady. Also the rules of evidence, primarily to impeach a witness or call into question the character of a witness. And this, for us legally in Arizona, falls under Rule of Procedure, Criminal Procedure Rule 15. And also there's prosecutorial ethics 3.8 that we have to disclose that same information. So they're all speaking to different components of the same thing, of an obligation to disclose this information to a defendant in a criminal case. The origin of the rule, as I said, goes back to Brady versus Maryland. Prosecutors must disclose the evidence related to guilt, innocence, or punishment. And that's disclosed to a defendant in a particular case. It's not a list that's published or a list that's maintained in our office. It's for each case, a defense attorney or defendant would have access to this information once it's disclosed. U.S. v. Giglio, prosecutors must disclose evidence related to the credibility of a witness. And this is where it really gets to the meat of the matter. It's a witness, might be an officer, it might be somebody from a retail establishment on a shoplifting case. So the defendant, if there's something in their past that's on this database, they can question them about it if a judge allows them to do so. Strickler versus Green, the obligation was expanded that we as prosecutors must disclose this material regardless of whether or not the defendant actually asked for it. The rules of evidence that apply, why this is important, is so someone can use this information if a judge allows them to use it to impeach the credibility of a witness. Say if it's something that goes to their duty, their ability to recollect information, or if anything untruthful they've had in their past, that they've been found to be untruthful in testimony, convicted of a crime, they can be impeached with that. Their character, which goes to their reputation for untruthfulness. If there's been specific instances of untruthfulness, say they testified untruthfully and that was reported, or they've had disciplinary findings of untruthfulness. These are all things that relate to the Brady database and information. Criminal conviction, any felony, that could be perjury or anything else, a felony conviction. Crime involving a dishonest act or false statement. Next, getting to the rule of criminal procedure that actually codifies this, makes this a requirement in Arizona. The prosecutor must give the defense any material that tends to mitigate or negate a defendant's guilt or reduce a defendant's punishment. This is the rule that lays that out. And this also is basically codifying what Brady and the cases that came after have said. It's important to note that the information is not disclosed to the public. We're disclosing this to a defense attorney on a case, and it's for the use in that case only. There's a three-step inquiry that we go through in this process. Our office reviews completed reports from the Professional Standards Bureau of the Police Department to determine whether that information needs to be disclosed. And again, we have an ethical obligation to do this. Includes any material that would negate the guilt, reduce the punishment of the defendant. This applies to all state's witnesses, not just police officers. This could be a witness who saw an accident and they're standing on a street corner and they are disclosed to the defense, and if they have issues in their past related to being untruthful or convicted of a crime, that will be disclosed. The judge ultimately determines whether or not somebody can use it in a trial, so it's important to note why it's a three-step inquiry. Prosecutor disclosing it, what it includes, and that the judge is the gatekeeper whether or not somebody can use it. It has to be relevant and probative to the case is what the judge is going to look at. The actual process, important because I'm sure you're all wondering, so what gets an individual on the list in the database? There are 6 general categories we looked at. The first one is conduct indicative untruthfulness. If they've found to lie at work, things of that nature, they've been convicted of lying, that can be reviewed for inclusion on the database. Also, arrest, pending charges or convictions. If they have a criminal charge that's pending, they've been arrested, that will also be reviewed for disclosure. Conduct constituting the elements of a felony. Even if the felony has not been charged, it's something that can be looked at that could be included on the list. Conduct indicating bias or prejudice. This example could be if somebody has demonstrated that they have taken inappropriate actions to somebody based on gender. Maybe you have a witness at a retail establishment that is only calling into question shoplifters that are of a male or female gender. They're indicating bias or prejudice. Repeated incidents of somebody having social media posts that are showing bias or prejudice, that can be considered for placement and disclosure to the defense. Repetitive conduct involving neglected duty, conduct unbecoming an officer, improper use of force, or failure to perform assigned duties. This could be somebody who's not properly showing up to duty, that they're not filing reports, they're asking for pay for time that they didn't earn. Those are all things that could get somebody on this list. And last, any impairment that might affect the ability to perform their job duties, complete reports, or remember events. And these are all important, and that last one as well, because it ties into, if you think about it, when a witness is going to take the stand and testify against a defendant, if they can't recollect the events, that's something important for the defense to be aware of and to consider. It could be that they have a drug problem. It could be that they even have a traumatic brain injury. If somebody cannot remember events because of their ability to recollect, that's something that could put an individual in the database. So what's important to note is that there's a range of conduct. It's not all severe felony behavior, and it also can be something that happened in a witness or officer's career 20 years ago when they first started with the force and they were put on this Brady database. They're still on the force, but this incident could be a minor nature, is still there. In addition, individuals are still on the Brady database if they've separated from the department, if they could be called as a witness, and I will cover that in a little bit later. What I said earlier about it being referred to as a Brady list, it's not really a list. In the past, prosecutors might have kept a list, and some may choose to do so. We don't keep a list in our office because a list does not satisfy the disclosure obligation and our ethical obligation. If we merely gave a name of an officer, what's important, what the defense has the fair right to, is the underlying behavior that led to the placement in this database. So mere disclosure would not be enough to satisfy our obligation under the rule or under case law. The obligation requires disclosure of the material that describes the underlying conduct to the defense in a criminal case where the officer or any other witness for the state, for the prosecution, may testify. And that's what I just mentioned. What's important is the underlying conduct. Just saying a name of John Doe, Bob Smith being on a list would not be sufficient. It doesn't tell you why. And the disclosure of the material is still characterized as a Brady list. You'll hear us refer to it. I even fall prey to it, but it's really a database, and it's the underlying material that is important. As I said earlier, we don't maintain a database. We disclose it where it's appropriate. How we learn this material, how does somebody get on the list? Completed reports come to us from the police department after their Professional Standards Bureau has investigated and submitted a completed report for us to review. If we learn of information, we can learn through a court, a judge or a defense attorney could tell us, a witness, somebody could call in. If they have some alleged misconduct, that can be passed on to Professional Standards Bureau, or it can be passed on to the supervisor of a witness who's not a police officer, somebody at a retail establishment. We review court findings. If a judge, somebody says that an officer or a witness was not credible, for the officer, that can trigger a PSB investigation, the Professional Standards Bureau. And we also get notification from the county attorney's office if an officer or a witness has been charged with a crime which may result or trigger that PSB investigation. We have an internal committee that reviews the reports to determine whether the conduct described must be disclosed. If the disclosure is required, the officer has a right to appeal their due process. They're an employee, they're an officer, they have due process rights, so they have a right to appeal our decision to place them on the Brady disclosure database. If the committee determines that disclosure is not required, no action notification is sent to the officer. But if the disclosure goes forward, they're going to be placed in the database, overriding their appeal. This is the next slide, that if that's over, the appeal is denied, it's going to be in the final report, is going to be uploaded for disclosure to the defense attorney. And it's only disclosed to the defense in cases where the witness may testify. If that witness is not even going to be relevant to the case or not even called to testify for either side, then that information is not relevant to the case and won't be disclosed. It's not to be passed on to the public. It's for use in the case pursuant to the same Rule 15, and the report may be obtained ultimately through a public records request through the source of the report, which would be the police department. The decisions that the prosecutor makes in reviewing these cases is work product. The actual discussions we have about why somebody should or should not be on the Brady list in the database is work product. And that goes to our written conclusions, correspondence between prosecutors, legal theories, our conclusions. That's all what's considered work product. That, as I said, would include the reasoning behind a prosecutor's determination that the material is or is not subject to disclosure. The categories I mentioned earlier, the untruthfulness, the convictions, the if somebody has a felony, but also if somebody has neglect of duty, conduct unbecoming, if somebody has an impairment. So you can see that there's a range of criteria that may get somebody in the Brady database, and it could be conduct that is major, results in termination from the police department, or it might be more minimal. Again, as I said, it could have happened years ago, but that shows you that it's a range of conduct. It's not just a bad person. That's not the intent of it. The intent behind this is fairness and due process for a defendant to analyze this information when it's disclosed and to see if they want to ask a court to use it in the court case to impeach a witness or call their character into question. I mentioned this earlier, but I want to repeat that this database, the Brady process, Rule 15, does not allow us, and we do not play any role as a prosecutor in officer oversight or discipline. That is internal with their own department. The disclosure determination is made based on the investigation, and it's generally after disciplinary and retention issues have already been addressed. If not, they're still going to be addressed by the police. That's not something that we play a role in. A question that was asked and why this item was on the agenda, I believe it was Councilmember Williams asked, and it's an important question of how does somebody remain or get off how long do they remain in the database, or can they get off the database? They're in there if there's any possibility they may be called as a witness to testify. And so you can have individuals that have left the Phoenix Police Department and gone to another agency, even got out of state, but they will still remain on our list if there's any chance they could be called as a witness to testify, because even if it's 8-10 years from now, that information is in the database for the defense if a court will let them use the information after we disclose it. Even cases on warrant, that will remain in the database indefinitely until the case is no longer at issue, the case is resolved. And if there's no cases left that an officer could be called to testify in, then that is one situation where they could be possibly removed. And changes in circumstances would be if they were charged with a felony and they've been acquitted from the felony, then that can be a basis for removal from the Brady database. If new evidence comes out, say that part of the investigation was a witness that lied in the Professional Standards Bureau investigation, that will be analyzed, and an officer can be removed from the database because the basis for being put in there was unfounded. Somebody lied in the investigation. That's all I have at this time. I'll take any questions.
Before we have any questions from my colleagues, Julie, can you please repeat the rules regarding public comments? I just want to make it very clear for everyone.
Yes, thank you, Chairman. So members of the public may speak for up to 2 minutes to comment on agenda items to be discussed. Comments must be related to the agenda item and the action being considered by the subcommittee. The reason for this is so that the public has notice of what will be discussed. These rules are based on Arizona Revised Statute and City Code, which has adopted Robert's Rules of Order. General comments that go beyond the scope of the agenda must be made in the citizen comment session at the end of the agenda. Also, as a reminder, to help our meetings go more smoothly, speakers should present their comments in a respectful and courteous manner. Profane language and personal attacks on members of the public, council members, or staff are not allowed. A person who violates these rules can lose their opportunity to speak. Thank you.
Chairman Nowakowski, if I may, prior to opening up to public comments or council discussion, Elizabeth Burton Ortiz from the Arizona Prosecuting Attorneys Advisory Council also has a complimentary portion of this presentation. It may make sense to let her do her small part before we have a more in-depth conversation.
Oh, absolutely.
Good morning, everyone. Thank you so much for the opportunity to be with you to explain Arizona's Rule 15.1 statewide disclosure database. We are, to the best of my knowledge, the very first state in the nation to compile a statewide disclosure database, and I'm really excited to share the information with you. My name is Elizabeth Burton Ortiz. I serve as the Executive Director of the Arizona Prosecuting Attorneys Advisory Council, better known as APAC, a little easier to say as APAC. So some of you may or may not be familiar with APAC. APAC has been around for over 40 years. We were created by statute, and the statute actually creates the membership of the council. So there is truly a council. The membership of the council is comprised of the Attorney General, the 15 county attorneys from across Arizona, the chief municipal prosecutor from jurisdictions with at least 250,000 in population, one at-large municipal prosecutor, which is appointed by the governor, the dean of the state of one of the state's 2 law schools, and last but not least, the administrative director from the administrative office of the Arizona Supreme Court. So all in all, we currently have 23 members of the APAC Council. Bob Smith is the municipal prosecutor, chief prosecutor for the city of Phoenix, is a council member. Our primary focus at APAC is training, and we train all year round. We do hour trainings, day-long trainings, week-long trainings, and we train on a variety of topics, primarily to assist prosecutors in developing the skills necessary to do their jobs. But we also do quite a few multidisciplinary trainings, often bringing in police officers or victim advocates or service providers on a wide range of topics such as the neurobiology of trauma, victims' rights, and so on and so forth. Although our primary responsibility and primary focus is training, we also on occasion undertake projects that can positively impact statewide the criminal justice system. And this statewide Rule 15.1 integrity database is one of those projects. So let's first talk about what the database is. As I said, to the best of my knowledge, we are the first state in the nation to have undertaken this project. And because we were the very first state, there was no template, there were no lessons learned from other jurisdictions, and so we took a very, what could be perceived as a very long, methodical process in trying to develop an overall plan to meet our goals. And our goals was to create or to put together a comprehensive database of law enforcement that have been placed in the integrity database by prosecution offices across Arizona. So our groundwork, our first step, if you would, was to create a multidisciplinary work group to develop best practices. Best practices for recommendations for law enforcement agencies, recommendations for Arizona Post, recommendations for prosecution agencies on how to pull together information, how to report information, and the processes. This multidisciplinary group met for, oh goodness, probably a couple of years. And we did not force the process. We wanted it to take as long as it needed to take. At the table were prosecutors, were law enforcement officers, were representatives from police unions. Anyone who wanted to be at that table were welcomed at that table. And I can tell you that because those meetings were held at the APAC office. Eventually, the work group, by consensus, put together best practices, and those best practices were taken to the APAC Council for approval. Now, I want to emphasize these best practices are a recommendation, although they were approved by the APAC Council. APAC has no jurisdiction to mandate that these best practices. We can't impose these on any office, whether it be a law enforcement agency or a prosecution office. These are simply best practices. And those best practices are available For those of you who would like to review them in detail, on the APAC website, everything, in fact, I'm going to talk to you about today is available on the public portion of the APAC website. Now, perhaps you're asking, why would APAC undertake this project? Well, there are two reasons, and why, number one, if you would, was to help prosecutors statewide comply with their disclosure duty. Now, Mr. Bob Smith has just given you all of the legal bases and legal parameters for why prosecutors, what and why, prosecutors must disclose as part of their legal and ethical obligations. Because it is not uncommon for a law enforcement officer to work in multiple jurisdictions over the course of his or her career, oftentimes it's possible that one prosecutor's office may be unaware of possible integrity issues with an officer that arose from another jurisdiction, say La Paz County versus Graham County, opposite ends of the state. That officer may have worked in both jurisdictions, and there may not be that easy, effective, and efficient constant sharing of information regarding officers on integrity databases. So APAC's first goal in creating this statewide database was to help prosecutors meet their disclosure duty, a one-stop shop, if you would. And our why number two was to help promote transparency. Because all of the information that we're going to talk about today is on the public portion of the APAC website, it is equally available to every single individual, whether it be a prosecutor, whether it be a member of the public, whether it be really anyone in our community, have equal access to the information on the APAC website. So let's get into the why, or excuse me, the how. The first how is that we created the database and we placed it on the public-facing portion of our website. We went about creating a structure, a process, where prosecution offices from across Arizona could supply APAC, upload, if you would, information into the database. Thinking this through and trying to make this system both efficient and effective, we created a process where each prosecution office identified one or more what we call database managers for their office. So in other words, not every single person in an office would have the authority by that office to upload information to the database. We wanted that to be a identified user, if you would, an authorized user. The prosecution offices, the first step was that we asked them to identify one or more database managers. Those database managers then were provided a process where they could then have information from their office integrity database uploaded into the APAC database. And those database managers have the authority then to either add information or delete information. So APAC itself is really a central repository, if you would. The APAC team members, including myself, have absolutely no authority to either choose to not add someone or not delete someone or delete someone on our own or what have you. We have no discretion as to the information. We are simply the receiving processing agency administering this central repository. Each entry into the database is a freestanding entry. And so what I mean by that is, let's just take an example of an Officer Jane Jones. And let's say Officer Jane Jones, it has her name and information submitted by the Cochise County Attorney's Office, uploaded into the database. and let's say Officer Jane Jones also worked in another jurisdiction, and the Yavapai County Attorney's Office also submitted that officer's name and information. Those will be two separate entries. And so if a person searching the database searches for Officer Jane Jones, then they will see those two separate freestanding entries. Those two entries may be based on the same underlying conduct or may not. That is not within APAC's purview. And each office that submits information to the database, they are then the only authority to later remove that. So in my example, Cochise County Attorney's Office would only have the authority to remove their entrance, if you excuse me, their input regarding Officer Jones, and the same with the Yavapai County Attorney's Office from my example. Now, what information, you may be asking yourself, is shown in the database, and what it shows is the officer's name. It shows the associating law enforcement agency, and it'll also show the name of the prosecuting agency which uploaded that information. The underlying information regarding why that officer was designated for the database is not part of the APAC database, nor does APAC have any information regarding those underlying conditions. We simply, again, have the basic information regarding the officer's name, the police agency, and the submitting prosecution agency. Any member of the public or the defense or prosecution agency, anyone who would like more information, then would need to reach out to either the submitting prosecution agency and or the identified law enforcement agency. Now, who can access this database? As I said, it is—
Elizabeth, this is Councilman Nowakowski. Councilmember Thelda, can you take over for just a little bit for me?
Will do. Thank you.
Thank you. Sorry about that. You can continue.
Thank you so much. So who may access the database? Absolutely anyone. And that access is identical regardless of who is tapping into that database. So whether it be a prosecutor, whether it be a defense attorney, a member of the public, a member of the media, we all go through the same process, even me. If I wanted to look into the database to see if a particular officer's name was in there, I would have exactly the same process and the same limitations, if you would. I would get the same information as any other person. Now, when it came time for APAC, once we had our best practices approved by the APAC Council, and we put the technical structure in place for this database, then we created a rollout plan. We placed the best practice policy on the public portion of the APAC website. This PowerPoint has the link to that. We also created two different informational videos. The core information is absolutely the same for both videos, but they are for two different target audiences. One is a video specifically targeted to law enforcement to explain what the integrity database is, and the other video is specifically focused for prosecution. Both videos are on the public portion of the APAC website, and people are certainly more than welcome to view both of them. Again, the core information is the same. We've presented it slightly differently, and welcome any and all people to look at those. Lastly, we sent out detailed letters to all the chief prosecutors across the state, giving them the details regarding what the database is, asking them to please identify a database manager, and encouraging them to then participate in the database, which is voluntary. APAC has no jurisdiction to mandate or require prosecution offices to participate, but we are doing everything in our power to certainly encourage that. The database went live, if you would, on October 1st of this year. And that concludes the information that I'd like to present. Included in this is my email address, though, and we are, again, very honored to have the opportunity to present this information. I have presented nationally and across the state on the statewide integrity database, and I welcome any and all questions that you may have.
Chairwoman, I think you may be muted.
Thank you for your presentation. Councilman Garcia, do you have questions?
Yes, thank you, Chairwoman. So going back to Mr. Smith first. First, if we could get some clarity. We keep hearing list, database, back and forth, interchangeable. Is it a list? Is it a database? And why is it one and not the other?
Okay. Council member, the term list has been used so long, we're just kind of used to it. And it's a database because we don't maintain a list. That what you've seen in the media, that a list can be generated like a public record request, I believe, is perhaps how the media got information from the county attorney to ask them to generate a spreadsheet to produce a list out of a database. That would be my understanding of the difference between the two of them. The database is to have both the name of the individual and the underlying report, because the report is what the defense needs to use if they're going to use it in a case. So, like I said, I apologize up front that using lists, because it's just a matter of habit, and all over the media, if you see law review articles, people talk about a Brady list, but we don't run around in our office or have in our desk like a spreadsheet of the names. It's the database for that particular case, but that's why it's just a common term of Brady list.
Are there other jurisdictions that have lists, and would you be opposed to having a list?
I don't know whether other jurisdictions have a list. Every prosecuting agency in the country should be doing this. Everyone in the state definitely should be. And the point of the list is, I just don't see the benefit of a list. And so it's something that we can look at. So I wouldn't say it'd be 100%, but it's the underlying information is what our obligation is to disclose that in a criminal case. That's the only way we even get this information. We're allowed to is because of that rule for court use. It's not a disciplinary tool. So having a list serves no purpose for us.
Okay, so things you've said today is we must disclose, and my understanding it's a constitutional obligation. Like you just said, everyone in the country needs to disclose this. Do you feel we're abiding by this, that we have full disclosure without a list present?
Yes.
I'll ask that. Do you feel we're abiding by fully disclosing everything?
Yes, it's something that we abide by all the time. We take it seriously because it's a duty, it's an obligation. It's our ethical obligation. We can lose our ability to practice law if we don't abide by this. And so it's a very serious duty that I take personally, every prosecutor does. And to clarify with Elizabeth's presentation on the statewide list, we will be participating. We're in the process of transitioning to a new case management system, and for technical issues, getting the information on the old system versus the new, it's more effective to put it up with the new system. But to answer your question about are we meeting our duty and handling it effectively, yes.
You also said earlier that you review PSB and then the prosecutor's office determines where it's appropriate to disclose. And you mentioned an internal committee. Can you speak more of who makes up that committee? And is that committee the one who determines whether something's appropriate to disclose or not?
Yes, we have an internal committee of 3 prosecutors that review the reports and determine whether or not the behavior is warranted to be in the Brady database. And then we have 3 separate prosecutors that are part of so there's an independent appeal process if an officer wants to appeal being placed on the Brady database.
The reason I asked this, and I said this when we had our briefing earlier in the week, that there's obviously the outward look. So you're a group of prosecutors who are essentially the witnesses you would use. You are the ones that are determining whether these witnesses can be put on this list or not. Do you feel like that's a conflict at all?
No, because it's our ethical obligation. We have to satisfy the obligation. If we were having an outside person do it or a non-prosecutor, like a lay person, we wouldn't be able to know that we're satisfying our ethical obligation. If I'm having somebody independent do it, for example, I'm not sure if you're suggesting an outside agency, there would be no way that we can confirm that we're meeting our obligation. It's something that we have to review that to see if it rises, because these are individuals, they're employees, and this is information that's why it's not disclosed easily, because it's part of their due process as well, and it's information that can be used against them in a court case, so we take it very serious, but I have no concerns that we're biased or not meeting our obligation.
So it's not that, no, I'm not suggesting an outside agency. I guess where I'm having trouble is the ability for you all to determine what's appropriate or not. And if how you explained earlier, one of the things I heard you say is it ultimately is a judge's decision to accept any of this information into a case or not. And so I guess my wonder is why not disclose everything? Why the need to hold some things back or determine what's appropriate or not? Do we not trust that judges can do that themselves? Or what is the difference between you all deciding something or then a judge? So it looks like it's getting vetted twice before it gets into a courtroom.
Well, that even the judge, though, wouldn't be able to satisfy whether or not we're meeting our initial obligation, though. The judge is analyzing it for whether it's probative or relevant to a particular case. We are analyzing it to see whether it's information that meets those different categories. If it goes to their bias, goes to untruthfulness, because you could have something, if it was just everything that is reported, something that doesn't even fall in one of those categories. I mean, just because PSB submits us an investigation doesn't mean that it even qualifies for conduct or behavior in the Brady kind of universe.
Okay, I think that's, I'll move on from that, but I do think there's, again, we're talking about perception, we're talking about reality. I'm not questioning what you're moving forward or not. I think there's just a perception issue there. Similar how I think we've heard folks talk about police policing themselves. I think having prosecutors determine what a judge or what others can see could be looked at as a conflict. If you can explain a little bit more for myself, and I'm trying to learn the criminal justice system and having this conversation at the same time. At what points in a criminal investigation would a Brady list apply? So I know there's obviously indictments, grand juries, there's an entire process before someone comes to be prosecuted and eventually goes through the court process. At what points would, I guess, a defense attorney have access to this information? I'll ask that question first and then I'll go to my next one.
Right. Council member, good question. It would be under the same rule, that Rule 15. That's our disclosure obligation. It talks about the timing of it. We would have to disclose that when a case is set to like pretrial conference. We disclose information. If information comes in, let's say, so normally we would disclose it up front as part of our witnesses, who's going to be a witness on the case. And then if there is a witness, let's say we have 5 witnesses. If 2 of those are in the Brady database, we're going to disclose the link for the defense attorney to go in and look at that information with that disclosure. So it's early in the case process. After charging, but after arraignment, but it'll be before, they're in conjunction when it's set to a pretrial conference. So it's pretrial, which is fair because they want to review it before trial. If we receive information, let's say after the first pretrial conference or during that period where some witness now is placed on the Brady database, we would disclose that as well. Because the whole purpose of it is if that person may be called as a witness, so the defense can review it and seek to cross-examine, to impeach them, or to get into that information. So we have to give it as part of the discovery process. So when you're asking about grand juries and things of that nature, in the city prosecutor, we don't have grand juries, but that would be up to the county attorney to disclose anybody as part of their witness process, their disclosure process.
Okay. Is there a problem with over disclosing? And I guess that's what I'm trying to go with. If what we want is to be as transparent as possible, we're obviously not saying this information is going to go public. It's going to stay within the criminal justice system. And at some point, a judge needs to determine whether this could be used or not. Do you feel like there's a problem with over disclosure or having a list, an actual list of names?
Well, as I said earlier about the list, I just don't see how the list gets you anywhere. And the list is becoming public with the statewide database, and more offices are providing lists. So if you just have a list of 150, 200 people and Bob Smith's on there, just that list doesn't really help you. It's the underlying conduct. But your other question about the underlying conduct and is there over disclosure, we err on the side of caution. I would be surprised if there are that many cases or individuals that don't get added to the list. It's a pretty, I guess, almost like liberal, where if there's behavior that's concerning that could be relevant and we're going to disclose it. So as far as any concerns about there being stuff held back, it's not something that we do. It's reviewed very intently, and it's veteran prosecutors that are looking at it, and so I don't think there's an issue with our disclosure. It hasn't been brought to our attention from, say, the defense bar that we're having we're not disclosing enough information.
Okay. So back to the internal committee or this process of who decides where the information gets out or not, how is that checked on? So basically, who is this committee accountable? Is it yourself, or who checks what's being disclosed or not, and if it's appropriate or not?
They, if there's any concerns raised with their disclosure, that would come to my attention. And how I'm involved, I'm one of the members on the appellate side of it. If an officer would appeal to be taken off the committee, or taken off the database, that would come to my attention, as well as two other attorneys. So we always try to keep it a odd number. So, because you could have somebody that there's voting where two people and the committee think that somebody should be and one doesn't. And so we have a balance to that.
I've heard of an extra step in, I think Philadelphia was one of the places that we looked at, that certain offices even create a do not call list beyond the, I guess, Brady database or list, where they acknowledge that certain officers' credibility is shot and they know that it's going to be brought up. And so there's a certain list of officers that just don't get brought in. Do you think that's something that we could or should do?
It's something that could be looked at. And I think that in the process, council member, that if a witness is, say, the sole witness on a case and they have such severe credibility issues, there's times where that could impact the case, where the case may not even go forward. If you have a case where, say, it's a DUI and the officer is the one witness and the information is so severe to damage their credibility, then the case won't even, so it's not a matter of just not calling, it's a matter of the case couldn't even proceed. And that's something that has to be evaluated by a prosecutor who's actually handling the case for each case. The witnesses they have, what issues they have, and are they going to be able to proceed. So, to be honest with you, that the cases, a lot of the individuals that end up on the list are for charges that are pretty severe, as far as the frequency of what they're called as a witness on might be at the county attorney level, a felony level. That in the misdemeanors, it's not like we come across a lot of officers that we're looking to call as a witness that are on the Brady database. You know, it happens now and then, but we haven't seen it to the extent where there would be a functional use of a do not call list, that we would have a large number of officers that are in some pool of do not call. And in my experience, I've been a prosecutor for 26 years, and I haven't come across where I would have a situation where I would need to develop a separate list, because it's pretty rare that it gets to be that severe in our court, in my experience.
Last thing about list or not list. So how would a defendant know to look for something? Or is it common practice that defense attorneys, obviously if someone's defending themselves, it's different, but do most defense attorneys just say they see a police report, they see an officer's name, and they ask you to check if it's on the database? And so just kind of trying to figure out, if we're not providing a list of names that they can cross-check and say, I have this case, is this officer there? How would they know to ask? Is it something that just everyone asks?
No, what in the presentation, that it's a proactive duty we're required to do, council member, and tied into the Rule 15 disclosure, we have a proactive obligation to disclose it. So a defense attorney, if we're doing our job, they don't even have to ask if these 3 witnesses are on the Brady database. We're proactively providing that information to them as part of our disclosure. Here's a copy of the police report, and we send it electronically, but here's a copy of the police report, here's the photographs from the case, here's our list of witnesses, and this witness is in the Brady database. Here's your link. We send an electronic link for the defense attorney to go in and look at the underlying report, because that conduct is what matters. So we're proactively doing it. What's that? Yes, and they're free to ask as well. If they say, okay, Bob, you've got 4 witnesses, you only told me one's on the Brady list, they can ask us. They can come and say, do you have information about that? But it's specific to that case. So just general lunchtime conversation, or they call us up on the phone and say, is John Doe on your Brady list? That's not appropriate. It's specific to their case. The defense attorney gets access to it for their case.
All right. And so if you said, we're doing our job, and I'm not questioning that, or I would ask, do you feel like we're doing a good job? But also, I think the second question, and especially with the reason we're having this conversation, the gang charges and what's happened and what's been in the media, do you feel that it's enough for us as a city? You said something earlier, this is not a measure of accountability and transparency. And that's fine, and I accept it. But as council, I think we are accountable to community to make sure officers are accountable and transparent. Do you feel the communication between your office and I know police is not here, I'm not sure if police is here, police's communication to MCAO is adequate? And then what responsibility do you think, and maybe this is for Chris or someone else, but what responsibility do you think we have as a city to disclose our employees? Or do you think, we're just kind of at the whims of MCAO deciding to disclose or not?
Well, first, counsel, that I don't know if you misheard me, or just to clarify that what I said earlier on was that this is not a vehicle for oversight or discipline. I never said that it's not for accountability or transparency, because I'm completely about accountability and transparency, and that's why we're going to participate in that Apac database that will effectively produce a list, I guess you could say. We're going to be putting a list out there anyway, so that's going to come where somebody could search and see that city prosecutor has added Phoenix police officer John Doe, so they'll know, as Elizabeth described, what agency put that individual on there. So I do think it's important to be transparent and accountable. But as far as your question about what the county attorney is doing, if they notify us that an officer has charges for the Brady database, we would disclose that. And so I guess I'm not sure exactly what you're asking about the county.
So, okay, so we give information to the county prosecutors, and then the county prosecutor is responsible for releasing our information, or does a defendant, even in county court, go straight to Phoenix if a Phoenix officer is involved to get our Brady information?
Okay, now I understand. The county attorney has their own Brady obligation, so for their cases and their witnesses, they wouldn't come to us. They would have each prosecution office is going to have their own Brady database, or if they use a list, they're going to have a Brady list. But for the underlying report, if it is a Phoenix officer, yes, you would go to the Phoenix Police Department to get a copy of the Professional Standards Bureau report. You might have seen, for example, that Channel 15 has a searchable with some PSB information. My assumption, I don't know, is that they would have done a public records request to obtain that information from the City of Phoenix Police Department.
Okay. Thank you, and sorry if that was a little long-winded. But I had some questions for Elizabeth as well, Chairwoman, is that okay?
Go ahead, proceed.
Thank you. So this started last October, and I wanted to ask Elizabeth, in your experience so far, who would you consider the model jurisdiction, or is there best practices in Arizona of folks that are disclosing things that are making it easier for you to compile your statewide list database?
Well, I don't have an answer for that because APAC has no jurisdiction to mandate or require, we simply receive that information. So I guess the short answer to your question is I don't reach out, nor do agencies, prosecution agencies tell me their processes. I could go to the APAC database and start searching for names, but that is really not the role of APAC to get involved in what individual prosecution offices are doing.
And so there's no regulations or values or generic ask of each jurisdiction to give you certain information. It's just basically whatever you're doing now, give us what you have.
Well, I can tell you what I've done, and APAC is a really small little office, and so the outreach was done by me personally, where when I say we have a rollout plan, we created this body of hard copies and electronic copies, and then I did an individual reach out to as many offices. Amazing people took my calls as many times as they did, simply saying, listen, this is what we have. Do you have any questions? Is there anything I can help you with logistically? And so we have encouraged in that way. But no, I certainly, it is not my role, and I have no authority to be making direction or mandating.
Okay. Yeah, I mean, I like the way you said it at the one-stop shop, that, the idea would be great. Again, my question is, if there is no kind of qualifying information that you're asking for, I would hope that you're getting, I guess, equal information from all. Do you feel that's right? Do you get to assess that every jurisdiction is giving you similar information, or is it different? How have you seen that come in?
Well, I'm not sure when you use the term qualifying information, so allow me to expand a little bit about the process. It is, and forgive me, I am not a tech-savvy person, so I probably will use the wrong terms, but it is a spreadsheet. And so when a database manager from a prosecution office submits information or asks to delete information, they need to fill in certain categories. And so it is, again, the first and the last name. If there's an individual identifying ID number, if you would, for the law enforcement officer, that it is not law enforcement community, my understanding, it is not like with lawyers where each licensed lawyer has a unique and ever identified with them bar number. So we don't have that same process with law enforcement officers. But the spreadsheet that the database manager completes has very precise but limited information as to the officer's first and last name, the agency that they were with, the police agency, and then the prosecution agency that's submitting it. So the information APAC is receiving is standardized in that way.
Okay. You mentioned earlier how folks came together to create or think through this database. Was there inclusion of defenders in that, or public defenders, or any sort of defender, as folks who, yes, on the other side of prosecutions, but would be requiring or accessing this information?
Not to the best of my recollection, and I'm sorry for the fuzzy answer. It's been years ago that we started this process. It seems like I've lived with it for so many years. I can tell you that my recollection, though, is that every so often someone new, a new name, would reach out to me. And again, we are a really small office, so all the calls go to me. And I would say, you want to come? Come to, here's the next meeting, and give me your address, and I'll put you on the distribution list. And so, or email address, and put you on the distribution list. So I can't specifically tell you that we had members of the defense bar. You know, this process is really one of identifying processes for sharing integrity database information, and that is within, that is information to be disclosed to the defense. It is not information that the defense has ethical obligations for disclosure on. So it's a little bit out of their purview, with all due respect.
Okay. You also mentioned a couple of times now delete information. Why would someone go in and delete something?
Oh, absolutely. Because as Mr. Bob Smith mentioned, there may be circumstances where the underlying bases that placed an officer on the integrity database have changed. And you know, the one example that comes to my mind is perhaps an officer, you know, might be regarding alleged conduct that upon further investigation, what they were deemed to not have committed. And so they were cleared of that alleged conduct. So that could be a circumstance. Another circumstance could be if they were placed on the integrity database due to a medical issue that impacted their memory, and that medical issue thankfully eventually got resolved. So there could be circumstances upon which the underlying reason for initially placing them in the database have changed. And so we certainly want to have that opportunity to have that database be as current and be as accurate as possible.
Thank you. And my last question, it sounds like you're not in any way going to be a regulatory organization or going to be coming to Phoenix and saying, hey, Phoenix, you're not doing this right, or you're not giving me that type of information. And so I guess the question I'm wanting for you to confirm is, the onus and responsibility still lies within Phoenix to release our information, correct? There's not a state agency or someone regulating or looking to make sure that we're doing it right or not?
The disclosure obligation lies with each individual agency and each individual prosecutor, and I myself am a career prosecutor. So when Mr. Bob Smith talks about that deep connection of making that determination as to whether or not circumstances merit placing an officer in the integrity database, that's something that really struck a chord with me. And so no, to answer your question, no, it's not Apac. To the best of my knowledge, there's not another state agency that is going to be doing that. That's something that is very, very personal in a professional way to individual prosecutors and to prosecution offices. That's my license on the line, and with all due respect, that's my integrity on the line when I make those professional decisions.
All right. Thank you so much.
Absolutely.
Thank you,
Thank you.
Chairwoman.
Madam Chairman, Councilman Garcia, if I could just add to that, as far as the oversight that we're doing our job and doing it correctly, it really comes as a matter on a case by the defense attorney and the court in hearing the case about whether information is disclosed. If cases are coming up and information comes out that was not disclosed, that's going to be a problem. So the office is subject to the court and corrections to that, but more specifically, the attorneys that make the decision to disclose that or not disclose that and are found to be wrong, there's an ethical problem, and their bar licenses and ability to practice law, as was mentioned before, are on the line if they don't meet their disclosure obligations.
Thank you. Anyone else? Betty, do you have a question? Councilwoman Barago?
I
Go ahead.
do. Thank you so much, Chairwoman. Yes, I have a couple of questions. Not exactly sure for who this question is, but here we go. So I just wanted to specifically ask about the hiring process for the police department, and I needed some clarifications. It's my understanding that police officers, the disciplinary records are purged after 5 years. This is something the state legislator enacted that is statewide. Is that true?
Councilwoman or Vice Mayor Williams, Member Guardado, I'd have to actually defer to PD on that piece because I'm not exactly sure on the purging side. So I'd have to defer to Assistant Chief Kurtenbach.
Is he here? Is he there?
He is. He's coming to the table now.
Okay.
Chairwoman, Councilwoman Guardado, I want to make sure I understand your question. It's specific to hiring processes, is that correct?
Yes. Well, it's more, okay, so I just want a clarification on this because it's my understanding that police officers' disciplinary records are purged after 5 years. And is this something the state legislator enacted that is statewide? And I just wanted to know if that was correct.
So thank you for that clarification, Councilwoman. I think where the confusion lies is where the record exists. The record is never purged from the city HR file. It will exist there for the entirety of the employee's career, and I believe 5 years beyond their separation from the department in the case of the police department. What happens sometimes is there's some internal files where there is language included in MOUs or MOAs that govern purging, the term that is used, but it never goes away.
Got it. So my follow-up question then to that is, so let's say, someone, a police officer that was from Chandler or from Peoria, decide to come to the city of Phoenix. Do we get all of their records given the situation, or how do we make sure that we're not hiring officers from another part of Maricopa County that that might be on the Brady list?
Chairwoman, Councilwoman Guardado, the simple answer to your question is that we have a process within our Employment Services Bureau whereby we ask the applicant whether or not they are on the Brady list, and then we will do, and I use the term colloquially, right, as Bob said, we still use the term list sometimes, whether they're included in that database, and we do our own checks. Also, please remember as it relates to discipline, because I'm really focused on underlying conduct, not just whether or not somebody's behavior got them on a list. We are all in the state of Arizona governed. We receive our certification at the Arizona Peace Officer Standards and Training Board. So we look to that governing body to ensure that that employee is certified and in good standing as well. But we do a comprehensive background that includes an applicant's placement on a Brady database.
And then my other question is then, so let's say you have someone and they say, no, we're not on the Brady list. Then you go out and you do your investigation and it does turn out that they are on the Brady list, then what happens?
Simple answer to that is that we would not hire that individual.
Great. Okay. And how do we use the Brady list in the police department, in our HR department, to making sure that everyone that we hire is not on that list? Like, do we go by that list as we're hiring folks?
Council member, or Chairman, Chairwoman, Council Member Guadardo, the Brady list, the database, the Brady database, we've got to recall that this is information that is generated for our Rule 15, our disclosure process. So, as I said earlier, we don't have a list, so it isn't a matter of where we create some list and then back share it with the police department or share it with our HR department that these are individuals, because we were only given that information because of our duty or obligation to the court process and as prosecutors to then disclose it to a defense attorney in a given case. So the what you're asking about, does the city use a Brady list? That's why I just got to get away from that, because there isn't a Brady list in the city of Phoenix that is shared around in different departments for we have witnesses on some list. It's specific for a court case to disclose to the defense.
Got it. Okay. Well, thank you. Thank you for that. I mean, I definitely then do think that, you know, we should be, and this could be a conversation for, I know it might be a different topic on this, but definitely think that, you know, we should have some sort of database that we can actually use to making sure that everyone, you know, that gets hired onto our police department has a clean record, has a great record in terms of being able to work in our police department, as we're seeing with all the different issues that we do have. But it seems to me that the Brady list isn't, or database or whatever. It's going to take me a minute to get used to calling it something different. It's an important tool to use in hiring process to ensure the city prevents problematic officers from working in our police department. I think it is important for us as a city to think about how we are building community trust. I think we need to ensure that no officer we hire into our police department has issues of integrity, with prejudice, bias, or with truthfulness. The Brady list offers our city a tool to identify these unacceptable pitfalls and actively avoid them. So definitely, I know there's, you know, we still have a lot of work to do when it comes to this. I appreciate the presentations and I appreciate the work that's being done on this, but definitely a lot more to be done. Thank you.
Councilwoman, if I could just follow up, if I could follow up real quick, that the Brady information, I don't know if this would answer the question, but the Phoenix Police Department, as part of their policy, does consider if somebody coming in from a different agency would be on that agency's Brady database. So if somebody was trying to move to Phoenix, I asked the police about this. If somebody's trying to move to Phoenix from California, from Chandler, as you mentioned, and they will ask and see if they're on their Brady. But I guess what I'm trying to say, and whether we say list or database, I don't mean that, it doesn't in the end, I think, really matter, because it's the underlying conduct, what I believe all of us and what you would want them to look at, as you said, for the integrity and the individual that's trying to apply to the city of Phoenix, the underlying conduct that got them on that disclosure information, what did they do? And the police department looks at that when they're making their hiring decision. So that's what's really critical. This is just kind of like a name or a label that gets you to that underlying information, and the police, as a part of their policy, have Brady lists in their policy to consider for an applicant.
Got it. Thank you. Thank you, Chairwoman.
Thank you. Councilman Garcia.
Thank you, Chairwoman. To Chief Kurtenbach, could I ask you a question? I don't know if he's still up there. Okay, now we can see you. So I understand that this information cannot be used for discipline, but do you take into account assignments. If you're gonna assign someone to a certain unit, a tactical unit or otherwise, that they may be on the database?
Chairwoman, Councilman Garcia, I'll answer it this way, it depends. There are certain assignments where, depending on why an individual is included in the database, we believe that it wouldn't be appropriate for somebody to work in those assignments. But as Bob said before, and I alluded to earlier, what I'm really focused on, and we as a department are focused on, is the underlying conduct. What was the behavior for which the individual was disciplined? What was the level of discipline? And was there something within that discipline that would preclude that individual from working in a certain assignment?
Okay. And you said earlier we wouldn't hire someone that's on a list. And I know this isn't used for discipline, but I don't know the way to ask this question. At what point does an officer become a liability to both the department and prosecutors that we either have to let someone go or reassign them to a different type of work? Does that get taken into account? Does that happen?
So there's two parts to your question, if I heard it correctly, council member. The first related to hiring. And what I can say definitively, because we checked, you may recall that from January of 09 to March of 15, we did not hire. So we started hiring again with a group of 15 officers in March of 15. Since then, we've hired approximately 1,400 individuals to the position of police recruit. And I always make that qualification, police recruit, because not everybody makes it out of the academy. Of those 1,400 plus individuals that we hired to the position of police recruit, not one was on a Brady database at the time that we hired them. So it's just an important distinction, and I alluded to it earlier for Councilman Guardado, that it is part of our Employment Services Bureau hiring practice. As it relates to working internally, I'll go back to what I've said before. It's the conduct, the underlying conduct. There may have been a behavior that one of our officers engaged in where they could be a very productive member of our department in certain assignments, but perhaps it wouldn't be appropriate for them to work in other assignments. And that's something that we do actively consider. Hopefully that makes sense.
Yeah, that makes sense. How do you access the information from other departments? Is it based on an applicant saying they work somewhere and then you go back to that place? Or do you have the ability to access multiple databases and just say, go through all of them to see if an officer had worked there or not? Or was on the list or not, sorry, not worked there.
So, Ms. Chairwoman, Councilmember, so we're talking about a lateral hire is what you're specifically asking for, somebody who worked for another agency that now wants to work for us. So then we would reach out to, first off, we're going to ask the employee. And as Councilman Guardado mentioned before, if somebody were to lie to us about that, subsequent to that interview, we learned that they were untruthful, we would never consider them for our employment. That's an automatic disqualifier. And then, quite frankly, what I believe would happen is Arizona Post would not allow them to be certified anywhere in the state of Arizona. Ultimately, that's not my concern. I'm only focused on the Phoenix Police Department. But what we would do is we would go back to the jurisdiction from which that applicant came, and we would make that inquiry as to whether or not they were included in a Brady database in that jurisdiction.
Okay, and now saying officers leave the city of Phoenix and want to work somewhere else, what does the Brady list we would share with another police department, is that the same list that our prosecutors have vetted to kind of be cleared? Or how would someone access or know, let's say your equivalent in another police department calls and says, hey, was this person on a Brady list? What list do we use to determine or give them information?
Madam Chairwoman, Councilmember Garcia, that I believe that in that situation that you would have where if an officer had been investigated, say by the Professional Standards Bureau, that they could look into that. It's a public record, but we don't have a list. PD would know who they sent to our office, for example, of who to look at for Brady, that information that they would have. But I guess I'm not sure what you're asking.
I'm hypothetical. I'm Yavapai County Sheriff's. I'm calling you. I'm hiring John Doe. Is John Doe on your Brady list? What answer do we give them, or who answers to them?
Let Chief Kurtenbach handle that.
Ms. Chairwoman, council member, we would share that information with them. So if one of our employees attempted to gain employment with another agency and they reached out to us, much the same way we reach out to other agencies, we would disclose information that we have.
So is that a Brady list, or is that a PSB investigation list? What list would you go to? Because you said we check with other jurisdictions if someone's been on a Brady list or not. So if someone wanted to check with us, it doesn't sound like we have a system to do that. And so being the largest city in the state, I don't see how other cities would do it if we don't have an effective process or an ability to release that. Or it sounds like that. We don't have like a go-to list to go to if another jurisdiction in the state calls us to say, I'm hiring your officer or a person that was in your department, or were they on the Brady list or not?
Madam Chairman, Councilman Garcia, I can answer that. I mean, that is part of what the Apac database is going to assist with. Prosecutors can look and see whether somebody's on that list, then they could follow up on that. But normally, if a jurisdiction is looking to hire in someone who's been a Phoenix police officer, they would contact, just like they're doing a reference check or a background check on the employee. We would be going to the employee's file to look at the reports and the information that was in there, not looking at a list to find out whether there might be something you need to report. We'd go directly to the employee file.
Okay, thank you. So it sounds like even if our intention is not to hire someone that's on a Brady list, it might not be easy for us to determine that. Because even at ourselves, I think we would have trouble being able to share that or...
Chairwoman Williams and members of the subcommittee, one thing I would add is, I think it may have been glossed over in the presentation from Bob Smith, is just by virtue of being on the Brady list itself does not make you not hireable by the Phoenix Police Department or any other agency across the state. It goes back again to the underlying issue. So if I'm hiring an employee in any department, police or whatever, and I'm doing a very thorough background check or reference check on that individual, and if they had something that needed to be disclosed, then it would come up in my reference check. Now, the police department hiring process is even more thorough than any of us probably have ever been through in our lives. So a lot of the things that would come up in that way. I think the other thing I want to emphasize that the Brady list itself is not a tool for PD to share. That is a database that is maintained by the prosecutor. And correct me if I'm wrong on that, Bob, but that is a key to remember on this database.
That's absolutely correct. Yes, for the limited, Madam Chairwoman, Council Member Garcia, that is correct. It's for the limited purpose of the court case. But to be clear, what I said earlier, the Brady database is not used for police oversight or discipline. They've already provided us that in-depth information, the underlying concluded report. So they're going to have that. And I think what Chris and Jeff and Chief Kurtenbach have gotten to is that if Yavapai County called, they're going to look for the personnel information, any history of that officer, because of how in-depth their hiring is to become an officer. They're going to want to have the underlying conduct of what that person might have had in their personnel issues with the City of Phoenix Police Department. So, Councilmember, asked your original question, there is a process in place. The person would call and they would be directed to the Phoenix Police Department or personnel to find out about the record of the individual. It wouldn't be to the prosecutor's office just to see if this person is in some database. They've got the underlying conduct they want to get from the relative department, that being the police department.
So we wouldn't be able to tell, again, going with this example, Yavapai County, yes, this person's on a Brady list, yes or no? Would we give that information?
To the Yavapai prosecutor, I guess who you're...
No, so we went on to say our police department seems like before they hire folks, they've asserted they check if they're on a Brady list or not. So where I'm asking is, are we being responsible if other chiefs are wanting to do the same thing or other police departments? And so if they call us, would we automatically share with them that an officer was on a Brady list or not?
They would have to go for the underlying information of their concerns with that officer, not if they're on a Brady list or not. Once we share the information on the statewide database, they're going to know it in any event. But I've never received a call like that, Councilmember, I guess is what I'm answering. So if the police department has, I don't know if they get calls, the chief, if you know, if you get calls if somebody's on a Brady database.
Chairwoman Williams, Councilmember Garcia, let me be clear about our hiring practices. You said it before, but I want to make sure everybody understands. So we affirmatively reach out if there's a lateral officer trying to secure employment with the Phoenix Police Department, not only to that officer's former agency to get their IA, or in our case, Professional Standards Division file, but we affirmatively reach out to the prosecutorial agency, city, county, where that officer is coming from, to see if there is information that their name is on such a database. That's what we do. I can't speak for what other agencies do when they attempt to hire our officers, but that's what we do for Phoenix.
Thank you.
Are there any other questions? I guess I have one quick question. I'm a little confused on hiring practices, and you say you would talk to Phoenix HR. Would you give them the information in the file or the information about the Brady list? Or do I have you thoroughly confused?
Madam Chairman, I believe that the information to be given is whatever is in the personnel file. HR would have it or police would have it. The Brady list doesn't include all of the things that an employer might want to know about employees. It's just a specific category of things going to witness credibility that the Brady list is about. But there could be other things that employee had performance issues or attendance or other things that would come out of the personnel file. So generally, the Brady list is only a very small subset of the things that an employer would want to know about employee. So they would contact personnel, or they would contact the department that the employee worked in this case, perhaps police, to identify and do the reference checks about what is in the employee's personnel file and in their employment background.
And I would assume, based on that, Chris, that the reason they're on the Brady list was the information would still be in their file.
Madam Chairman, I believe that would be correct for most of the information. Certainly anything that I can think of that would amount to a Brady list information would certainly be maintained in the file. The file contains a lot more information, and it has to be kept for most items until after the employee has left the city.
Yeah. Thank you. Thank all three of you very much for your presentation.
Chairwoman, if I could
Yes.
intrude, I think we have 11 speakers on this item, and we also received 36 e-comments on this item. If you'd like to go to the public comment.
Okay, let's do the calls next. You will call them, correct?
Yes, ma'am. Our first.
Thank you.
You're most welcome. Our first speaker is Hava Derby. Hava, are you on the line?
Hi.
Please proceed. Yes.
Thank you. Hopefully I can help clear up some of the confusion. At this point, you've said absolutely nothing that helps out understand what the Brady list is. Let's be clear that, first of all, if you want to go watch Full Disclosure on ABC 15, Dave Biscamine has unpacked all of this for you, and I'll cover some of the highlights for you. Currently, there is no statewide list. There's no mandatory responding to AZ Post, county attorneys. There's no meaningful oversight. There's no meaningful punishment for withholding Brady evidence. So we'll start right there. And I'm going to jump into the Anthony Armour case, a case that showed how prosecutors, county attorneys work together to make sure that evidence is not shown in a case. He had a history of lying and abusing, and that history was kept from the attorney in his case. That we found out later he was taking pictures of recording his interactions with women. That case, the county attorney sat on it while Frances Salazar sat in jail after Armour arrested her for drug possession at a traffic stop. Fingerprints, drug test, body cam, just the word of none of that, just the word of a liar. He's on the list because he's a liar. And she sat in jail for 22 months. Protests have come out of this crisis of trust, and we need to trust the cops, and we can't. This Brady list, which 1 out of 30 cops in Phoenix is on that list, including Tactical Response Unit, which arrested protesters. You have a history of covering up for the misdeeds of police officers. These people are liars. That's why they're on the list, and that's very important information. Thank you.
Our next speaker is Vanessa De Carlo. Vanessa, are you on the list?
I'm on
The line, excuse me.
Hello?
Please
Can you
proceed.
hear me?
Yes, please proceed.
No, can you hear me?
You might want to turn down
Hello?
your volume a little bit. I'm getting a bit of an echo.
I see it. Hold on, is that fine?
Much better,
Sorry.
thank you.
Okay, great, thank you. Okay, so there's a lot of confusion around this, so I'm just want to be clear for Bob Smith. So you need to drop the charges for all the remaining protesters, especially someone who claims to understand the Brady violations. As I understand it, and clarify if this is wrong, that the Tactical Response Unit, the folks that have actively prosecuted and arrested members, that they are all Brady list or in the process of being investigated by the Brady list. So it's really confusing that those people are transferred knowing that they are on the Brady list, going to other departments, actively being involved in prosecuting and really making up and lying about charges of these protesters right now. And what are you going to do about that? Also police who seek pay for time, that they didn't earn. To me, I would see that as a Brady violation. So 15 million for overtime for riots that didn't happen. How was that not a Brady violation? And another thing. So why is this process not transparent? It's very, very confusing, and this really hasn't answered any questions. I would like an itemized, something that really explains this. In every other job there, list, database, whatever semantics you want to go over, psychologists, doctors, Brady lists exist where public can see. So I want to know if I'm going to be protesting and I'm showing up, are the majority of the people going to be there arresting and have a history of lying? Like, it's just a good thing for the community to know that this entire department is problematic and that should be really disclosed to the public. And additionally, this.
Our next speaker is Anissa Groves. Anissa, are you on the line?
Yes, can you hear me?
Yes, please proceed.
Thank you. As usual, you have an ever-growing list of serious threats to public safety that the public is demanding you address, but instead you are treating this time as some kind of in-service training around the most basic elements of our non-existent system of police accountability. And even better, you turn it into a semantics lesson that no one understands, literally making everyone listening less intelligent and less informed with the worst kind of gaslighting. We have to remind you week after week that police have been lying under oath to justify false felony charges against protesters. Police have been circulating neo-Nazi coins to celebrate their violence. The city manager, police chief, and county attorney have been openly enabling this behavior. All of this is just a horribly violent distraction from the unending murders of Black and brown folks by our police department, and you have basically done nothing to address any of this. If you're going to discuss Rule 15, you need to address how ridiculous it is that the PSB makes the decisions about this list. How unacceptable it is that we have to desperately grasp at a list that is not intended as a disciplinary tool because there is no other way to hold police accountable. How this additional state-level database nonsense clearly does not make any difference whatsoever. And since these databases are all we have, how about you demand that every officer involved in these coins and political prosecutions be placed on them, if not already on them, and that the lists be duly consulted in the course of these investigations. But all this discussion has done is clarify how worthless all your damn databases are. What we really want is for you to do your job and address the real issues. Fire Ed Serker, fire Chief Williams, fire all the cops and prosecutors involved in the political prosecutions. Demand all charges against protesters be dropped with prejudice. And Bob Smith, you also need to drop these charges right now. Never hire another cop, no matter what list they are on or not. And if you can't do these things, then fire yourselves, all of you.
Our next speaker is Hannah Heyman. Hannah, are you on the line?
The violent anti-Black white supremacist Phoenix City Subcommittee of Bootlickers is here in full force this morning. Let's go back to kindergarten for a moment and practice our listening skills, because I really don't believe you're capable of determining whether or not our comments are relevant when you clearly don't understand what's going on in this city as a direct result of your white supremacist policies. We have to call into every meeting to explain your own agendas to you. So don't you dare tell us our comments are not relevant when you're not even willing to give us 2 minutes to explain ourselves. The Brady list is less than bare minimum. We're demanding an end to the murderous anti-Black slave catchers known as Phoenix PPD, not for more paperwork telling us how violent they are. We know. The fact that you do not understand this incredibly basic, flawed, and wholly inadequate database is further proof that none of you should be anywhere near this table. If you use the Brady list at all, every single cop within PPD would be on it. Every single one, including chokehold Jerry and Curtin Bach. Every single cop and every single one of you on the subcommittee should be removed from the city payroll and run out of town for the murderous violence that you condone. Every meeting you refuse to abolish the fascist Phoenix police is further evidence that you are our enemies. The fact that you are still paying these neo-Nazis with our tax dollars is beyond disgusting. And it's sad to say, but we can write the script for how this plays out every time. Nowakowski will tell the murderous pigs that he's sorry we've hurt their feelings with our comments while they let blood dry on their guns. Zelda will wake up from her nap only to agree with whatever racist bile Nowakowski is saying. Carlos will ask a couple of questions, say something about feeling bad that folks got cut off, and then shrug his shoulders and go along with whatever the rest of you do. Betty will prove yet again that she doesn't pay attention to anything that happens here. All the while, Ed is buying new shoes online with the over $300,000 we pay him every year, and plan how to spend his pension after he resigns for paying violent neo-Nazis to prey on Black residents. Abolish the police, close the jails, and get out of our city. You all need to be held accountable for upholding the violence of this fascist state.
Our next speaker is Kelly Kwok. Kelly, are you on the line?
No, no more karaoke.
Hold on just a
That
second.
would be animal rights.
Hold on. Unfortunately, we have lost a quorum momentarily, so if we could hold, please. Oh, it looks
Matt,
like...
I'm actually on.
Oh,
Yeah.
okay. Thank you, Chairman. We can proceed then with Kelly Kwok was our next speaker. I'm sorry, Kelly's not on the line. Our next speaker is Grace Logan. Oh, Grace is also not on the line. Our next speaker is April McHugh. April is not on the line. Our next speaker is Lola Nzangu. Lola is not on the line. Our next speaker is Patricia Paglucia. Patricia, are you on the line?
I'm on the line. Thank you so much. Can you hear me?
Yes, please proceed.
Thank you. So Bob Smith, our chief city prosecutor, and Elizabeth Ortiz of Apac, or wherever you're from, thank you so much for those really long presentations that didn't really clarify anything at all. The database list 15, Brady, whatever you want to call it. It's just full of violent, anti-Black, lying murderers, and none of you are doing anything about it. City Council, I really don't think you actually understand it any better after this almost 2 hours of conversation. The Public Safety and Justice Subcommittee, you all should know what the Brady List is and what it does, since you vote repeatedly on items where Brady knowledge is relevant and necessary. It is appalling and unacceptable that you use our city time for a presentation that really you should have researched before you ever got on council, perhaps. Let me just give you an easy summary so we can all understand exactly what Elizabeth and Bob explained to us. The Brady List doesn't help at all because the cops that should be on it are not, and prosecutors don't even use it anyway. The PSB, which we all know, Professional Standards Bureau, all cops are dirty liars. They're all supporting white supremacy in each other. So there's absolutely no accountability, truth telling, or integrity in this carceral system because it was literally designed to oppress Black folks. And we see you all showing up here doing your exemplary work to maintain this system. Each of you that work for City Prosecutor's Office, APAC, City Council, PPD, and MCAO, all of you clearly hold white supremacy as your dearest value. And instead of supporting and protecting human life, you're maintaining this unjust carceral system. So we see you, and we are here in solidarity with Black leadership to demand that PPD is defunded, that all charges are dropped, Bob, all charges, and the criminal justice system.
Our next speaker is Marisa Leyva. Marisa, are you on the line? It does not look like Marisa is on the line, and then our last speaker on this item is Jamar Williams. Jamar, are you on the line?
I am. Can you hear me?
Yes, sir. Please proceed.
All right. Thank you. It is kind of wild to hear Mr. Smith talk about being proactive and being super diligent. The only reason we're talking about Brady and another case that Mr. Smith probably knows about, the Milky case, is because prosecutors not only were not diligent and not proactive, but they were actually taking efforts to hide evidence from defense attorneys and from defendants so that they could get prosecuted and couldn't defend themselves. Those are due process violations. It's kind of wild for me to hear Mr. Smith talk, and I'm a local criminal defense attorney, talk about Rule 15. If you asked Mr. Smith right now if Rule 15 was anywhere in Brady versus Maryland, he'd tell you no. That's because there's a constitutional rule that's much more important and much more significant. It's called due process in the 14th Amendment, the whole basis for Brady and the Milky case. It's so difficult to hear y'all talk about Brady disclosures as if prosecutors don't make mistakes, don't miss things, or can be just relied on to trust themselves. There's a big group of cases Bob didn't speak of, Elizabeth didn't speak of, and that's everyone who's charged with felonies who go through MCAO, which are initiated by the Phoenix Police Department. When these prosecuting agencies and systems, we have to just trust that they rely on themselves to vet Brady information, don't disclose Brady information, we're literally risking people's lives and putting people in cages and significantly subjecting them to violence just because Bob tells us it's okay and Elizabeth tells us it's okay. Brady was decided in 1963, and Elizabeth is here patting herself on the back for creating a Brady list last year.
No, Kowski.
Matt, is that all the callers?
Chairman, yes, it is.
Alrighty, Councilmember Garcia.
Thank you. Matt, can I ask Jamar Williams a question? Is he still on the line?
I'm here.
All right. So, Jamar, you're a public defense attorney. Can you explain a little of your interactions with a Brady list, or how it would work or not work for you? Or how you use it?
Absolutely. So Mr. Smith, and I've never met Mr. Smith. I'm sure he's a great guy, but Mr. Smith talks about this sort of absence of value or no value at all whatsoever of having or maintaining a Brady list. This is literally something that prosecutorial agencies across the nation maintain, in addition to whatever Rule 15 or local discovery rules that require them to do their due diligence to disclose information. So, I mean, he's being very dishonest or disingenuous when he says that to the council. The problem with the process he's describing is he's not accounting for when prosecutors make this internal determination that something is not relevant, or they miss something, or they hide something, and it doesn't get into the hands of a defense attorney. That three-step process that he described, he put the last step on there, being a judge. We should be able to trust judges in this system if we hire them to do the job that we hire them to do. Therefore, prosecutors should err on the side of more disclosure, not some discretionary process that they decide. They're not protecting anything. All this information is public. I have a very specific example. I had a client who was looking at a life sentence if he lost his trial. The prosecutors disclosed Brady information in that case, but they didn't disclose Brady information about a gang expert. And that might sound familiar to some of you because it was a problem that came up recently in protesters' case. This is a gang expert who's testifying to put my client in prison for life. Just out of concern, the judge in that case said, hey, prosecutors, it seems to me that Chief Williams doesn't understand what the Brady list is. It seems to me that Alistair Adele doesn't understand what the Brady list is. Can you go back and double check and make sure you're disclosing everything? This is after, in an interview, that same police officer lied to me and told me there was nothing in his personnel file that I should be concerned about and nothing of disciplinary nature. The prosecutors then came back and said, oh, sorry, here's this information. Here you go. That officer's not on a Brady list. He isn't in a Brady database, but that's Brady information that was disclosed to me on the eve of trial. I used that information in trial and that client was acquitted. His life was at stake because we cannot trust prosecutors to do this on their own. We need other systems that provide a check and balance on what the public can see about problematic officers and lists that defense attorneys can rely on and judges so that they can ensure that the constitutional Brady requirements are met and local rules of criminal procedure.
Thank you for that. And so you don't need to disclose, but it sounds like you had to do extra work to get information that should have been given to you. And this question, I guess, is for both Jamar and Mr. Smith, is in that situation, I don't know, again, if it's true or not, but in a hypothetical situation like the one you just described, who holds those folks accountable? Like, and I guess this is to Mr. Smith, like who would hold, let's say the situation that was just described or a similar situation, who holds someone accountable for not disclosing that information in a situation like that?
So I'm not talking about, and if I can correct myself, I'm not talking about a hypothetical scenario. This is a real case that happened. A real person's life was saved because we got information that we needed to protect his constitutional rights. In that scenario, that prosecutor made a big mistake, a huge mistake. And he will not be held accountable. I heard Elizabeth and Bob both talk about, oh, my license is at stake. They know that most likely if they make these mistakes, nothing's going to happen to them because they know that person is going to go away in jail or prison. And because they control this information, because they're the gatekeepers of this information, no one's looking back at the numbers that we need to say, hey, was there anything that happened here that should have been looked at again? Hey, well, was there anything wrong with the disclosures that happened in this process? Those instances where that information is discovered and then applied in an appeal scenario are very rare to benefit a client. And they know this. Elizabeth and Bob both know this.
So I guess, Jamar, since you're still on the line, last question for you is, what kind of thing would you have? I don't need to know how you obtained that information, but what extra work did you have to do, or how would you find Brady information as you described it if it's not given to you?
I can, as an attorney, because the system is not reliable and not trustworthy, as an attorney, I cannot just call Bob up, and maybe Bob didn't mention this because he currently doesn't practice in felony jurisdictions, but I just can't call Bob up and say, hey, are these officers on a Brady list, and then take his word at it. I'd be a very bad defense attorney if I did that. I have to submit public records requests with the city of Phoenix for officers that I think I need to look at their personnel files, which could take months, 6 months, maybe even more in some scenarios, because we have a bad public records disclosure process with the city. I have to go into court and say, hey, judge, I think there might be some information here. Can you order that the prosecutor disclose these personnel files? There's no guarantee that a judge is going to grant that order. Or I have to ask officers in interviews, hey, do you have anything in your personnel file that is of interest to me or that I should know about? And because they know it's hard for me to get this information, because they know that records are destroyed in some aspects, they often lie about this information. And these lies are assisted, through either lack of diligence or maybe malice, and sometimes by prosecutors who don't do their job and are trusted just to make this determination on their own. That's why it's so important for our city council members and other systems that are involved in the criminal justice system to provide checks and balances on whether or not this information is getting to the public and getting to people so that people don't go to prison and are subjected to state violence.
Thank you, Jamar. And so if I could ask, I don't know if it's to Chris or Bob, what would happen in a scenario like that where we didn't disclose something? How would we go back or be held accountable for that?
Mr. Chairman, Councilmember Garcia, I can't speak to a specific situation I don't know all the facts on, but I'll tell you, I think what you're getting at generally is that there is accountability, and it's what we have mentioned, and what's been mentioned is the court and the state bar. Number one, we're all aware of prosecutors that didn't abide by these situations. They've been disbarred, they've lost their bar license, and the court. If a defense attorney feels that information wasn't disclosed, if that's discovered later, the case, they can bring that up in a post-conviction review. They can also bring it up in an appeal. That information will be reviewed. So it's not just light that someone's saying they're risking their bar license. The case itself, justice is at issue. So if the information isn't disclosed, the accountability will be our court system and the state bar that licenses those attorneys. Yeah. And if an attorney didn't disclose it, that they're going to have to answer to that. That's the accountability. So there is the check and balance through the court system and the state bar.
Thank you.
Is there any other questions for my colleagues? With that, this was information and discussion only. So we'll continue to the next item, which will be item number 5.
Chairman Nowakowski, members of the subcommittee, while Assistant Chief Scott Walker gets settled in, just to give you a little background, these next 2 items are items that we've discussed with you over the last couple of years as it pertains to capital needs for our public safety department, specifically the fire department. And so this is kind of building off of those conversations that we've had over the past couple of years and looking at ways to be more strategic and to actually plan for the future. And with that, I'll turn it over to Scott Walker.
Thank you, Jeff.
Thank you, Mr. Barton. Good morning, Chairman Nowakowski and members of the subcommittee. As said, I'm Executive Assistant Fire Chief Scott Walker, and I appreciate the opportunity to be here today to provide the subcommittee with an overview of the fire department's recent strategic fire station planning efforts. We actually began this effort about 2 years ago, and we're proud of the work we've accomplished. I wanted to start by providing you with an overview of the service the fire department delivers to our community, as well as some of the key factors that govern that service. Phoenix Fire Department is an all-hazards fire department. What this means is we deliver more than just fire service. We certainly respond to fires of all types throughout the city every day. We also provide emergency medical response. That could be a cardiac arrest, that could be a drowning, that could be a minor injury, a fractured ankle, something like that. We respond to about 180,000 EMS calls every year here in the city of Phoenix alone. But we additionally respond to hazardous materials incident. This could be a confined space, or a overturned tanker on the freeway, a leak at a rail car, or any other type of a chemical spill. And technical rescue. As you see the mountain rescues we go on regularly here in the city parks, we also go on confined space rescues, collapses, anything like that would be a service we provide. And then finally, we provide for our own patient transportation service here in the city of Phoenix with our own ambulance service. And I wanted to point out this is really the most effective solution and efficient use of resources in a modern city like Phoenix, because you really reduce your redundancy in people. We could go to a fire call, leave there, go to a EMS call, go there to a mountain rescue, and then return to the station. So it is a highly efficient system. So for the fire service, and certainly the Phoenix Fire Department, response times are critical. This is really how we gauge our performance. So we use the NFPA as a standard to measure ourselves against. That NFPA standard says that a first fire truck should arrive on scene within 5 minutes and 20 seconds. We know this is critical because fires are burning hotter and faster than ever, doubling in size every 30 to 60 seconds. So time is critical that we get there to respond, effect a rescue, put out the fire. Also on EMS incidents, time is tissue. We know that the longer it takes us to get there, the worse potential impact of that patient is if it takes us too long. So to achieve this goal and to meet this standard, it is key that as we look to cover 520 square miles for the city of Phoenix, we have fire stations strategically located. Really, this creates that network across the region. This allows us to dictate where a fire station goes, which drives what type of apparatus and the number of apparatus in those stations, which then drives how many firefighters and what type of training they have in those stations. And holistically is how we achieve the response time standards we're looking for. It's important to point out that demand for our service has only increased over the last decade. From 2009 to 2019, we saw year-over-year increases, even during the poor economic conditions that we saw after 2008, and we increased our demand for that service by 43% over that decade. Unfortunately, during that same time, understandably in those economic conditions, our capacity did lag. We only were able to increase that capacity about 6%. So we saw this diverging trend line, and this is really what brought us talking with the fire chief, looking at where the city was going and growing, is we needed to start looking very proactively. So we're ready not just for today, but for tomorrow's needs as well. So that really drove us into a strategic and proactive approach. And so we started looking at our current and future needs. We looked at response times of our current apparatus, call volumes of our current apparatus, where we knew growth was happening, where we anticipated growth was happening, where we saw new development coming. And as we know, the city is growing really in all directions and up in the downtown area. So with that information, we were able to create the map that you see on the right side of this slide. And this shows current fire stations, along with what we are proposing and believe we will need over the next 20 years to serve this community. This effort was not done alone. We collaborated with many city departments. We meet regularly with the planning development staffs, particularly the impact fee folks, to really know, again, what development's happening, also what type of revenue in those impact fee zones might be available for us to utilize. We work with the Community Economic Development Group and Christine Mackey. So we want to be part of those early conversations when big development's happening. It's much easier to plan for a fire station, and maybe they can build their site plan around where we need to be before they build a building, obviously. So we work with them. We work with the real estate department. They are a great partner helping us find potential sites for future fire stations as we're looking out into the future. But more than just looking for land and building a station as we have traditionally done, we're looking for innovative opportunities as well. We've considered and considering public-private partnerships. What could that look like for the city of Phoenix and the Phoenix Fire Department? We've looked at, could we put a fire station in the bottom of a high-rise building here in the downtown corridor? We're assessing that. We've even had one conversation about the potential for a fire station in the first few floors of a parking structure. All these are opportunities that are on the table as we look to serve this community. And hopefully you've noticed the transition to a data-driven decision-making process. We certainly use that in this process as well. We want to make good, logical, and objective decisions to make sure we're using the resources you provide to us and our community provides to us as most effective as possible. And really this is about, as I said, planning for the future. We need to meet today's needs, but we need to be prepared for tomorrow's needs because they will be here soon. We know the city of Phoenix and the county is growing probably some of the fastest in the country, and we want to be prepared for that. So out of these efforts came this document you see now in the presentation, and we're very proud of this. We've shared this with the real estate department. This is what they use to go out and look for opportunities for us. So they might find a piece of property that became on the market, or excess ADOT land, maybe near the freeway, state land that may become available, or even city-owned property that we might be able to use. If and when they find a location in these areas, as we've identified what future stations look like over the next 20 years, where we think they'll be needed, and what apparatus will be needed, they provide us those locations, and then we can model that to see what would the impact be to that community. How will it impact response times? How does it impact the companies, the fire companies around there? Because as they get busier, being pulled into these other areas, it impacts their response times to their primary area, which we have to call that a secondary impact. So this document is proven very productive. And in fact, we're achieving results. The picture in this station is our latest station, Station 55, built up in North Phoenix, serving that community well today. We've also been able to now have approval with your support and full council support for Fire Station 62 down at 93rd Avenue in Lower Buckeye. And this effort to bring this forward to council really was out of everything I've described to this point. We're using impact fees. We knew the data set of fire station was needed, and we're going to be able to serve that community much better in the next 2 years when that station's complete. We've also had other successes. We've found a site in North Phoenix that we're working to acquire. That will help us in that area as well. We've identified a site in West Phoenix that we potentially could be Fire Station 77. Again, will have a real impact according to modeling to that community. And lastly, we've found a site down in the downtown area, in the Warehouse District area, that could be a potential fire station and special event site. Fire station every day, but as we bring big events to Phoenix, the Super Bowl and things like that, we know this population swells here in the downtown area. And that poses a specific challenge to public safety to serve those large numbers of people. So this site could also be that special event site, where we could stage resources in the site and respond out of there. Our medic teams, walking teams, that type of a thing. So we're really proud of what we've already done so far, and think this will continue as we look into the future. So finally, this is all about, for us, ensuring service delivery to this community. We want to make sure that we prevent any further increase in response times and hopefully drive those response times down. As I said, it is critical we get there in time to make a difference. We want to make sure that we're realigning that capacity demand that I discussed. It was on a diverging trend line. We want to get that in parallel, and certainly capacity lags a little bit demand, but we want to make sure at least keeps up with demand as best as possible. And we want to make sure, as I said, the future needs can be met. We know that this city, what it will look like in the next 10, 15, 20 years is not what it looks like today. There'll be further and more pressure on us to serve the community. We want to make sure we're ready for that. And then it really, I would say the vision is we want to make sure that future leaders, city leadership like yourself, city leadership at City Hall, fire service leaders, really have an opportunity to serve the community. The goal is that we can at least buy properties so that when the need arises or catches up to that property, we're ready to put a fire station there. Much of this will happen much after I'm gone and the current fire chief is gone from the department, but we're thinking 5, 10, 15, 20 years out. And so we really are proud of the work we're doing, and we wanted to share that with you and what we're moving towards in the future. So with that, that does conclude this presentation. I will be happy to answer any questions you might have.
Do I have any questions for my colleagues? Chief, thank you so much, and thank you for your hard work and looking into the future to make sure that we have fire stations throughout this growing city of Phoenix. With that, should we go to item number 6?
Chairman Nowakowski, members of the subcommittee, this next item again is kind of in the same vein. It's about planning and it's about being resourceful, but it's also about something, Chairman Nowakowski, I've heard you talk about over the last couple of years, and as my time as former budget director, about needs versus wants. This item is very critical. It is the thing that sustains our firefighters as they play the role that they play as putting out fires and saving lives. And so we need to plan for replacing their SCBAs. In the past, we've relied on debt financing and bond programs to replace these. And we need to get out of that situation and be more proactive. And so what we're proposing and what we have presented in the 5-year forecast and will also be in the upcoming trial budget is a plan to replace the SCBAs every 10 years. And with that, I'll turn it over to Scott.
Thank you, Assistant City Manager Barton. Again, Mr. Chairman and members of the subcommittee, I'll be presenting this presentation to you as well. Thank you for this opportunity to really bring to you this request to replace the fire department's self-contained breathing apparatus, or we really affectionately call SCBAs. So this is a very brief presentation for you. I wanted to just start with telling you a little bit about what the SCBA is and why it's so important to us. So if you see in the picture on the slide, the SCBA is the air pack that firefighters wear. It's the harness, it's the bottle, it's the face mask that you see this firefighter wearing. This is what allows us to go into a contaminated environment and do our job that we need to do. Simply put, the SCBA is one of the most important pieces of equipment a firefighter utilizes. As I said, it allows us to go in those environments to do our job. It is a matter of life and death for a firefighter when we need to wear it. It's important to also point out that the NFPA standard, as I've already mentioned, is something that we gauge ourselves by and really utilize to hold ourselves accountable to, requires that a firefighter, anytime they work in a oxygen deficient environment or a contaminated environment, must wear an SCBA. They also must wear it if the environment may potentially become contaminated or potentially become oxygen deficient. So as we talked, we're an all hazards department, so there are several occasions on a daily basis our firefighters would wear an SCBA, more than just on a fire ground. Could be in a confined space, could be in a hazardous material incident. Something like that would all dictate the use of an SCBA in order to effect our job. SCBAs now are really more than just an SCBA or an air pack. They now have the Integrated Personal Alert Safety System, or PASS device. So this is the system that allows us to know where and locate a firefighter if they became unconscious, unresponsive, or trapped and are not moving. This system is tied in the SCBA. When it notices or senses no movement, it alerts. When I got hired, this was a little yellow box that we wore on our belt that just alerted with a audible tone. Now, as technologies have advanced, this is integrated into the air pack, as I said. It senses lack of movement. It has a very loud audible tone that goes off, but it also has lights, LED lights that are tied into the harness straps, into the back of the bottle, so we can not only hear and to find that locator, that firefighter, but we can also see the flashing lights in these environments. As you can imagine, something can be full of smoke where you may not be able to really see your hand in front of you. This is one of two ways we may be able to find you, with either lights or sound. So the air pack is really much more than just an SCBA. Simply put, there's no margin for error on our SCBAs. They need to be good working SCBAs. We need to keep them as modern as possible, and firefighters need to be well trained with them and know how to use them. Firefighters are trained actually blacked out in a mask in an SCBA because it has to be instinctive. It has to be muscle memory. It has to be such that if you're in that environment as I described, you have to know how to work that SCBA, and it has to come through for you every time. So now just a little bit about our current inventory and why we're making this request of you is our current inventory is greater than 10 years old. And while in most things that may not seem like a long time, with SCBAs it really is. Advances happen regularly, technology changes, we learn more from lessons, unfortunately, oftentimes bad outcomes with firefighters in a situation, that lessons can be learned and improved into the design of the SCBA, and that's why it's important that we keep up a modern SCBA. It's also important that we use, as I talked about the NFPA standard, there's a standard for SCBAs, as you can imagine, so our current units are built to the 2007 NFPA standard. On this standard, because of technology changing rapidly as it does, we generally see about every 5 years a new standard for SCBAs. So there has been a 2013 and a 2019 standard change on the SCBAs, and it's also important to understand that if we fall out of compliance by more than 3 standard changes, we are now deemed uncompliant or non-compliant with our air pack. And so that's why one of the reasons we're bringing this to you now at this time, because we do anticipate another standard change in 2023-24, and so we would be out of compliance if that change happens before we can replace our packs. Our current packs just simply lack many of the new protective features that we are looking to gain by a new system. Some of those include what's called universal buddy breathing. So one of the features is firefighters, different size firefighters breathe different amounts of air. You could have one firefighter low on air. They may need to share air with another firefighter if they're deep into a building and can't get out quick enough. Well, currently, our packs can only share with the same pack. All new packs are designed to a standard that all SCBAs, regardless of manufacturer, can share that air. So as we run with Glendale or Scottsdale or Tempe or another city, this is a feature we don't have today that could be really save a firefighter's life if in that situation were to arise. We would gain that. New packs are designed to be decontaminated much more effectively and quickly. This is important as we know that the risk to firefighters from cancer, well, any material left on an air pack is off-gassing for several hours. So the better we can clean that air pack, the less chance of off-gassing and impact to firefighters' potential exposure to a cancer carcinogen. We also know that new packs, as I talked about, have the LED lights built into the straps on that PASS device. Our current models do not have that. And so those are just some of the features that we're lacking today that we will gain by the new SCBA's. We're having difficulties obtaining parts, the manufacturers, because as I described, they assume we're going to be moving into the new generation, and across the country, that is an assumption because we would be falling out of compliance if we do not. They've stopped making parts, and so we're struggling to keep parts in stock to repair our SCBA's and keep them in working order. And then on that same really principle is replacement units are simply not available. We actually bought up several units last year so that we could ensure we had enough SCBA's for any future apparatus we added to the system, or to replace any apparatus that just simply fails, or any SCBA that simply fails and is no longer usable. So those are just some of the challenges we face today with our current inventory. So what we're asking, as I said, to replace our inventory, and just some of the highlights of what we're asking for is, I wanted to point out first that we did defer this request for 2 years. We wanted to make sure we were better in line with those standard changes. We also want to make sure we were being fiscally responsible with what you've entrusted to us and our community gives us. So we could extend this delay, or this request, for 2 years. We felt it was the right thing to do and get us in line with those perils. So we did defer the request. We are asking to replace the entire inventory. And while generally we think about things, it's better to do a phased approach. When it comes to SCBA's, that is not something that is really a good solution for us. The reason being, as I said, firefighters are using these devices in a contaminated environment, smoky environment, maybe zero visibility. They need to know how to operate every button, every knob, everything on that SCBA completely blacked out. We can't have a firefighter come to work on one day, work on a fire truck with one SCBA, and then go to work the next day on another truck with a different SCBA and have some type of emergency or catastrophic failure and not know where everything or how everything works on the SCBA. So this is an item that generally needs to be replaced all at once. Our new SCBA's will meet the most current and latest NFPA standard, gaining the advantages I talked about, the decontamination, the universal buddy breathing, the improved pass alert device and lights on the straps, those types of things. Simply put, the new SCBA is going to provide better protection for our firefighters. We all are always seeking for those best opportunities to make sure our members have the best and latest gear as possible to ensure they can go and do the job that you ask them to do. We will make sure we work with the finance department that a procurement process and a competitive procurement process is accomplished. As again, we want to be fiscally responsible to make sure we're doing that, so we will do that process. The finance department will bring that back, I'm sure, when the time comes to you for approval to make the purchase. And then lastly, we are estimating this cost of this replacement to be at $10 million. This will be replacing all SCBA's, allowing us all some reserve, number of reserves. That way when we're maintaining, we can have those still in service. We have SCBA's at the training academy, on all fire trucks, on all resources. This also would be the spare bottles we would need for the SCBA's. It would also be an inventory of parts so that we can maintain the new SCBA's as well. And as Assistant City Manager Barton said, we have funding in our budget for about $2.5 million this year. $7.5 million funded in next year's budget is the proposed plan, which would affect this purchase. And we're very excited about the sinking fund concept that has now been developed. It allows us to save for $1 million a year. In 10 years, have $10 million, replace that SCBA again, that whole inventory again. This keeps us consistent with the standards. This keeps our firefighters in the most latest, really, units, safest units for our members. And we're not going to impact the general fund in a negative way this way. So we're very excited about this opportunity, and I really now have a permanent plan for the future to do this. So with that, that does conclude this presentation. I am happy to answer any questions you might have.
Do we have any questions for my colleagues? And Matt, do we have any calls to the public or cards from the public on this one?
We do not, Chairman.
All right. Well, first of all, I just want to thank you, Chief, for making sure that our men and women are taken care of and that they're safe when they're running into the fires to save our loved ones. And this is for discussion and a possible action. Is there a motion on the table to approve this?
I would move approval. I think this is very creative on how to fund these for the future.
Second.
Okay, we have a motion and a second. Any discussion on this? If not, then all those in favor say aye.
Aye.
All those opposed? Motion carries. Thank you so much, Chief.
Thank you.
So we're next on the call to the public. Do we have any other cards from the public?
Chairman, we do not.
Alrighty, so then we have future agenda items. If any of my colleagues have any future agenda items at this time.
Chairman.
Councilmember Betty?
Yes, thank you. Yeah, so I mean, I don't know if, and this is more like a question for Jeff. I don't know if we can get an update right now in terms of the legislation that was just passed about the consulate IDs and how this is gonna help help our police department and how the police department is gonna use this. So I'm not sure if we can get a report on that now, or we can put it as an item on the agenda for the next meeting.
Chairman Nowakowski, Councilwoman Guardado, members of the subcommittee, what I would recommend to you is that we could put an item on the agenda for next month, but also we could come around and do individual council briefings with you to discuss that item one-on-one.
That would be great. Yeah, so we can put it on the agenda and then get briefings on that. That would be great.
We will work on it.
Thank you, Councilwoman. Any other future agenda items? If you don't happen to have any now, you can always present it to us later, right? Alrighty, with that, the meeting is adjourned. Thank you so much for attending.